Hello, my name is Steve Rinka and I'm with the Rinka Law Firm. Today's topic, we're going to discuss what are the employer and employee's duties in a situation where an employee suffers an injury and becomes temporarily disabled while employed. So for purposes of this hypothetical, we're going to presume that at the time that you were hired, you did not have any type of disability, or the employee didn't. And during the course of the employment, let's say it was 6 months, a year, 2 years, 10 years, doesn't really matter the length of time that the employee is employed. But during the course of the employment, let's say they suffer an injury. And this can be a work-related injury or an injury that was not work-related. Let's say you had to take time off to get a knee surgery because of a congenital defect in your knee. So in order to get let's say a ligament fixed on your knee, you needed to take time off. Okay, well, in those situations, what are the responsibilities of the employer and the employee? Well, number one, the employee obviously has to, in the case of, let's say you're going off to have surgery, to give the employer notice that the employee is going to be taking off time in order to have the surgery completed. Now, naturally, if you suffer an injury on the job or while you're not at work, you're not able to give the employer an opportunity about notice that you're going to have to take time off in order to recover. But in both circumstances, you're seeking to take time off from your work in order to recover from some sort of injury. Now, under California law, the employer has a duty to reasonably accommodate an employee who has suffered a disability. And disability is a very broad term. It's essentially any type of injury that affects one's daily life. So the scope, and under California law, they want to expand the meaning of disability. They don't want to limit it. So if there is any kind of injury that you suffered as a result of the disability, then you're going to be allowed to take time off. And how it works is, let's say you need to take off, you suffered an injury at work, you need to take off 3 months. What you need to do is you need to provide a doctor's note verifying the employer has a right to know whether or not you really need this accommodation. You can't just make a fraudulent claim. Obviously, this has to be a legitimate claim. So you need to get a doctor involved in order to verify the injury, and a lot of times what the doctor will do is they will provide a note to the employer saying that the employee will need 3 months off to recover from this injury. Now, under California law, allowing 3 months off in most circumstances would be seen as a reasonable accommodation. And let's say you have, Family Medical Leave Act that entitles you to 3 months off, so you can take that time off. Let's say you have vacation time you can use. Those are also things that you can use to extend your time off. One thing that's interesting about California law, it's very vague as to how much time off is deemed not a reasonable accommodation. There really is no set time frame that an employee can remain off work in order to recover from an injury, so long as the employee is progressing and is making a recovery. So, one thing with the reasonable accommodation under California law, there are certain aspects to it. Obviously, as in the employee, you can't make all these burdensome demands on the employer. The employer does not have to make such accommodations that it places an undue burden on either the employer or other employees. So if you suffer an injury and you receive treatment, and then through all this treatment, you are unable to still perform your job, even with reasonable accommodations. Let's say you suffered an injury and the reasonable accommodation is that you get a different chair. as opposed to the chairs that everyone else is using. Under that circumstances, in all likelihood, a court would find that modifying a chair for the employee, which will allow the employee to continue doing his job, would be a reasonable accommodation. But if it's a situation where an employee suffers an injury that affects their ability to lift anything over 10 pounds, and let's say that employee works in a warehouse where they're constantly lifting things 50 pounds and above, well, now what is an accommodation that can be made to help that employee do that job when they're limited to only lifting 10 pounds when part of their job is to lift 50 pounds? Well, in that situation, there is likely a good chance that if the employee is not able to lift any more than 10 pounds and there is no other job available for the employee, then the employer can terminate that employee because the employee can no longer do their job even with a reasonable accommodation. So, suffering a disability doesn't necessarily mean that you will become terminated. It really depends on the recovery process. And even if you don't fully recover from that injury, the real issue is whether or not you can do that job when you have gone through the healing process and you become what is used in the legal field is permanent and stationary. And what permanent and stationary means is that after all your treatment, you maybe did not receive a full recovery, so you're permanent and stationary, let's say at 90% capacity. So, your baseline is always 100% is just what you are when you're healthy. You can lift, let's say 100 pounds very easily. And let's say if you're at 90% permanent and stationary, means you can lift 90 pounds. You have 90% of your baseline strength. So if you are determined to be permanent and stationary, and as part of your permanent and stationary baseline that you can only lift no more than 10 pounds, well, now, if your job requires you to lift 50 pounds, the employer is going to be like, well, your doctor states that you can only lift 10 pounds, and your job requires you to lift 50 pounds. Since you cannot do your job, even with any kind of reasonable accommodation, because we need you to lift 50 pounds, the employer has a legal ability to terminate that employee. So, the real issues come down to what is a reasonable accommodation. And in addition to that, the employer has a duty before terminating somebody due to a disability to engage in what's called the interactive process. And what this consists of is the employer and the employee sitting down after the employee has essentially healed as well as they can. And if they're not 100%, the employer has to sit down with the employee to see if there is some way that they can accommodate that disability. So let's say in the situation where the person can only lift 10 pounds, the employee, and the job requires the person to lift 50 pounds, well, the employer can't just say, they get the medical records saying that the employee can only lift 10 pounds. Well, then, okay, let's just go ahead and fire them because he can't do the job. You can't do that. You have to actually sit down. And again, in California law, there's not any particular type of formality, but there has to be some sort of meaningful engagement between the employer and the employee where they do attempt to try and work out a resolution to see if there's some way they can accommodate the employee's disability. Now, most of the time, unfortunately, it's going to be a very perfunctory, very quick meeting. But if they have any kind of meeting, then that will likely constitute an engagement in the interactive process. And at which point, if they are not able to reach some kind of compromise, then they will terminate you. And the courts, despite what some employees may think, this isn't is very pro-employer as far as the level of accommodations that need to be made. I mean, they are not going to require an employer to spend a lot of money. They're not going to require the employer to create a new position to accommodate your disability. They're not going to require an employer to hire another employee to assist you to accommodate your disability. The accommodations that are required under the law are really accommodations that assist the employee, but do not place an undue burden on the employer. And again, that's another area of litigation. What is an undue amount of burden? We don't know. Again, it varies from person to person, circumstance from circumstance, the type of disability that the employee has suffered and has to be accommodated. So, it's an area where just because you suffer a disability and the employee does give you time to recover, that doesn't necessarily mean that you all of a sudden are entitled to a job once you've gone through, let's say, your therapy sessions if you can't do the job. I think that's sometimes a misnomer about employees and just a general understanding of California employment law that, the employer has to just accommodate the injured employee under all circumstances. Unfortunately, that's not the case. And if an employee suffers an injury that's work-related, that's where workers' compensation comes into play. And that's a completely different area, but just to kind of give you a little background for purposes of this informational video, workers' compensation is a no-fault system. So if you're injured on the job, even if you're at fault, even if it's due to something that you did that was negligent, you still get compensated. And you don't have to try and prove. You don't have to litigate it in court like you do with in an employment case where you have to prove that you were wrongfully terminated. Here in workers' comp, you don't have to prove that you were not negligent. Even if you were negligent and that caused your injury while on the job, you're going to get compensation. And that's why, again, if you suffer a workplace injury and you later cannot do your job because of that injury, the employer can terminate you. But then that's the thing with workers' comp, is the idea is that workers' comp at least provides compensation for the injured employee, even if they were negligent in causing their own injury. But I don't do workers' compensation. If you do have a workers' compensation attorney, you can contact me at 310-556-9653, and I can refer you to a very competent workers' compensation attorney. I specialize more in employment litigation, such as wrongful termination, wage and hour, harassment, discrimination, things of that nature. So I hope you found this video informational. If you do need any additional information, or if you know someone that has suffered what you believe to be a wrongful termination, feel free to give me a call. I offer free consultations. And again, my number, 310-556-9653. Have a good day.